Hi, everyone. My name is Matt Kugazaki. I'm from Inland County's Legal Services. Thank you all for joining us today. I think a few more people are kind of streaming in, so we'll let them in, but we'll get started. It's 12:01. So thank you for joining us for today's webinar. This is part of Inland County's Legal Services Small Business and Nonprofit Essentials that is connected with our small business legal program here. ICLS is a nonprofit legal aid organization that serves Riverside and San Bernardino counties. We provide free legal services in a whole bunch of different areas. Most relevant to and why you're here is that we provide free legal services to business owners and entrepreneurs in the Inland Empire. We are very excited to have our presenter today. His name is Ed Langhammer. He is an expert employment attorney. He's been an attorney for over 30 years, and he's at the firm Cozen O'Connor. He has advised, I don't know if I'm going to say this, but probably hundreds of businesses, probably more, on employment issues, and specifically about hiring and terminating employees. So we have a very great informative presentation for you here today. As I mentioned, this is just part of our small business series. So we have additional webinars throughout the summer. We're planning a program in the fall as well. So if you'd like to get information about our other programs, please visit our website. I think everyone here has a copy of that because I emailed you all today. My contact information will be at the last slide of this presentation, so please feel free to reach out. Also, if anyone has any suggestions for a webinar or a topic or any legal question that you may want answered and you think others may want it too, please let me know. We're always looking for suggestions on ways that we can help address issues in a webinar format or other ways, issues that small business owners are facing. With that, thank you so much for your attention, and I'm going to hand it over to Ed Langhammer.
Hi, good afternoon, everybody. We're at the crack of noon. Happy to be here, happy to talk to you. Yeah, I've been doing this stuff for a long time. I think when I started practicing law, there were about 10 labor laws. Now there's about 8 zillion of them. I'm kidding a little bit, but it's just been, the growth has been exponential over the years. And so what we're going to do is we're going to talk about hiring and firing. We're not going to cover everything. I've got a lot of slides. You're going to get the slide presentation when we're done. So you'll be able to refer to that as we go on. But let's just get going. The one thing we're going to say is our disclaimer, which is we're giving you general legal advice, general advice with respect to the laws, the rules, the regulations. We're not giving you specific legal advice. And what that means real simple is don't ask a question that goes along the lines of, hey, Joe's a pain in my side. How do I fire Joe? I can't answer questions like that. It's beyond the scope. You can talk to Matt, though, about seeing if someone can help you get answers like that. So we're not giving you specific legal advice. We're just taking a really, broad look at some of these issues to help you guys be a more informed business owners. Okay, so we're a big law firm. I think we have more than 800 now. We're in a lot of different places. I'm actually in the Santa Monica office when I'm actually physically in the office. That's me. Today we're going to talk about just an overview, federal, California, local laws to some extent. The interesting thing about here we're in California, we've got California laws that apply, federal laws that apply, depending on the size of your business. And then we also have a lot of local laws. A lot of cities and counties are actually passing their own laws with respect to employees, which some of you may be aware of. And then we're going to talk about terminating employees. So just overview of federal laws. We like to start off with this because this just gives you a little bit of information with respect to the number of laws that apply just on a federal level. And so we've got the Civil Rights Act, we've got the Pregnancy Discrimination Act, we've got the Americans with Disabilities Act. Disabilities are very broadly defined. The protected categories of who's protected by these laws with respect to the Civil Rights Act, for example, they're broad. I think there's 22, 23 different categories of folks who are protected, and the list just continues to grow. Age discrimination, 40 or over. You only have to be 40 to be subject to the protection of the age discrimination law. USERRA has to do with military leave. We won't talk a lot about it. And then on the California level, we've got the Department of Fair Employment and Housing. And the Fair Employment and Housing Act, and that is actually more protective of employees' rights than federal law is. We've got the California Family Rights Act, we've got pregnancy disability leave, and then we've got a lot of other just miscellaneous leave laws with respect to school matters, organ donation, crime victims. Let me give you this as a takeaway, because it's something you all need to know. And we're going to talk about wage and hour laws too in the next slide. But here's the baseline for you. If you have one or more employees, then you're subject to the sex harassment law in California, and you're also subject to the wage and hour laws. And there's some other laws in the bucket of wage and hour laws that you're also subject to. If you have 5 or more employees, then generally you are now covered by the Fair Employment and Housing Act. So all of those laws with respect to discrimination and retaliation are going to apply to you. If it's other types of leave, you may have to have a higher number of employees. For federal law, the baseline for federal discrimination laws is 15 or more employees, and it goes up from there depending on which law is implicated. Some laws actually have a higher threshold. So that's the thing you need to know. But if you only have, say you have 3 employees, does that mean that you're perfectly free to discriminate, harass, retaliate against people that have protected characteristics? I'd never give that advice. It's bad optics for a company. Odds are you'll get investigated. So I'll never give that advice with respect to, should I just ignore the laws if I'm a small businessman with respect to disability laws? So my answer is always going to be no, the optics are bad for that. You still may wind up getting investigated. So federal and state and local wage and hour laws. So again, we have this overlay. We've got federal laws, which is the Fair Labor Standards Act, and that applies to employers. Candidly, in California, we don't talk a lot about federal wage and hour law because California has their own law. And California laws are actually stricter for companies. And so the way all of these laws work is ask yourself one question: what law protects employees more? If it's federal law applies. If it's state law applies. If it's local law, then local law applies. So it's whatever law protects the employee best is the law that applies. So what does the California Labor Code do? It establishes minimum wage, overtime, meal and rest breaks, paid sick pay, lactation accommodation breaks, child labor. It's got lots of different laws in it. And as I said in the beginning, if you have just one employee, you are subject to California wage and hour laws. That means you have to pay people at least minimum wage. Minimum wage for small companies, small is 25 or fewer employees. So minimum wage for small employers is $14 an hour. Minimum wage if you have 26 or more employees is $15 an hour. And the law is now inflation adjusted. So right now we're thinking on January 1 of 2023, because inflation is now so high, the minimum wage is going to go up to $15.50 an hour. And so what we don't know if that's going to apply to small companies or not yet. We don't have clarification, and depending on what happens with inflation, that number could still go up. We have this law called PAGA, which we're not going to talk about a lot, but under PAGA, it deputizes your employees to go after companies who violate wage and hour laws. The penalties are steep, the violations are steep, and so even small companies can be subject to PAGA. Candidly, small companies have generally not been the target. People are going after much bigger targets, but small companies nonetheless could be brought into this. You can't if an employee has claims, or even if they don't have claims, you cannot require an employee from releasing any wage claims that they may have against you. And we talk about that because a lot of times companies they may want to get rid of an employee, there may be an issue on wages, and at the end of the day, you want to be able to say, hey, look, we want to resolve it with you, we want you to sign a release, but you can't get a release for wages unless there's a real serious dispute as to whether the wages are owed. And then local laws, again, minimum wage, paid sick pay. There are many, many local jurisdictions, many of them up north in Northern California, some of them down here, LA County, LA City. I don't know about the Inland Empire, but you may have other laws that you need to be mindful of. Okay, employment at will. Most of us know, or many of us know, that in California, we basically have something called at-will employment. And so what does that mean? That means that any employee or any company, with or without a reason, has the right to terminate an employee. And the employee has a right to walk away from a job at any time the employee wants to. And that's what at-will is. It's just, there's no specific duration, there's no written contract that says otherwise, and you can get rid of them. Or they can get rid of you. But here's the rub. You can't use an at-will provision as a get out of jail free card if what you've done is discriminate against somebody because of a protected characteristic, or because they complained about wage and hour issues, or because of any of the other protected reasons. So, and you can't retaliate against employees. There's claims that will come up. You'll be sued for retaliation. You could be sued for retaliation. You could be sued for wrongful termination in violation of public policy. If there's a written contract, if you have written contracts with your employees, then that could be entirely different depending on how you've written those contracts. And, so now we're going to talk a little bit about avoiding bias, because this is something that companies have to deal with. And it has to do now with making decisions to hire employees and onboarding employees. So you have to avoid, what we just say is you have to be even-handed with respect to any decisions you make to hire employees. And that means, with respect to, you only want to hire young people, you only want to hire old people, you only want to hire people of a certain, political, religious, so forth, persuasion. Any type of caveat or qualification you have really has to be related to the job people are applying for, and it has to be without bias. So what we say is, if you're hiring people, ask them the same questions, standardize it. If an employee volunteers information, you can't really use that information as a basis for rejecting the applicant. And then you could be liable for discrimination. All right, so protected characteristics, we talked about it. We're going to kind of blow through it again. These are some of them. It's race, color, national origin, sex, pregnancy, physical, age, religion, sexual orientation, gender expression, identity, military, state or local law. And so you really have to, as a company, whether you're a big company or a small company, you really want to avoid making pre-employment inquiries about protected characteristics. You can't really ask questions that are likely to elicit information about protected characteristics. You shouldn't ask for a photograph. That's something that was popular for a while, and a lot of times you'll get applicants who will submit their photos. Not so much anymore, but you can't require it. And photos, of course, can show protected characteristics. If you need it for ID, get it after you've made an offer of employment. COVID, we talk about it. COVID's still here, it hasn't gone away yet. There's still issues for employers that are dealing with, can you only hire people that are fully vaccinated? Can you only hire people that are fully boosted? Can you make conditional offers based on proof of vaccination? Those are all issues that are still being dealt with. They're still being determined through the court. You really have to have a serious, legitimate, good faith reason to want to do this stuff. Testing and vaccination mandates, it's still an issue for companies. There are issues with respect to accommodating people in the workplace. There's other laws that will apply. And with respect to to COVID, you're also required, even if you're a small company, you're required to have an OSHA plan in place, a workplace prevention plan to prevent injuries. And you're also required under California OSHA to have an emergency temporary standards plan to deal specifically with COVID-related issues. And that applies even if you only have one employee. So, well, actually, it applies if you have more than one employee. If you have 5 or more, it applies. I kind of correct myself on that. But you want to be careful with respect to implementing rules and regulations with respect to with COVID. Prior salary, you can't ask people what they used to make. It's prohibited. And you can't rely on salary history as a factor. And then there's other places like San Francisco have other laws that are in place. So hiring employees, let's get to it. So what kind of questions can you ask? And again, you're going to get this information. You're going to get a PowerPoint at the end of this. You don't need to memorize it, but a lot of the point we make on this slide is a lot of information can be gotten just by how you characterize it. So, you can ask somebody their name, you need to know their name. You just can't ask somebody what their maiden name is. That implies that whether they're married or not married, languages that they read, if it's relevant to the job, the name and address of parent or guardian is acceptable. The photograph may be required after employment, job-related organizations, without respect to omitting any references to protected characteristics, relevant skills acquired during military leave. So there's lots of things you can ask and there's things you shouldn't ask. And a lot of times it's just how you ask it. So the point on this is be careful. If you use applications, you need to be careful about using applications. A lot of times what we do, and what we do as small companies is we'll go online, we'll try to find a form. I need an application to hire an employee. So I go online and I download a form. You just need to be careful because an application form is really valuable for companies to have. It's sort of a gateway to the hiring process. And you have to ask questions that are really relevant and it helps you to screen any applicants. But you can have things like impermissible inquiries. It's the stuff we already talked about. Age, race, sex, protected characteristics. So be careful with anything you download off the internet, anything you download with pre-printed forms. Just be advised, be careful where you get them. There's reputable sources, there's some sources that aren't so reputable. There's stuff on the internet that applies outside of California, not inside California, so you want to be careful. You can't charge somebody an application fee to charge for the opportunity to get a job. You can't require people to shop at your store or eat in your restaurant or make a purchase before applying. And then ban the box we talk about. And that's just, you can't anymore, since 2018, you can't inquire about criminal history prior to a conditional offer of employment. So if you have an application form that says, have you ever been convicted of a felony? That form is not acceptable anymore. And you have to also be careful if you're in San Francisco, city of LA, because they have their own versions on that. So arrest and convictions, same thing. As far as that if they just got arrested but they're not convicted, you really can't ask about it. If there's convictions that were sealed by the court, expunged, statutory eradicated, non-felony marijuana convictions, if somebody's out on bail or released OR, there's other exceptions, and cities and counties have their own laws. So just the point is, be careful what you ask for. We see this all the time. And one of the things I always say to companies is, be careful what you ask for. If it's necessary to have certain information because that's a legitimate issue and concern that you have with respect to making a hiring issue, make sure you ask it properly. But don't ask information for information that you really don't need with respect to the particular job that people are applying for. So can you ask about conviction? Sure, but you have to make a conditional offer of employment first. And then there's this whole process that you have to do with respect to if you're going to deny them. If there's a preliminary denial, they get a chance to respond. So there is a process if you're going to be asking people about convictions. EEOC guidance. Now, I told you the EEOC is the Equal Employment Opportunity Commission. They are the federal agency that regulates employers that have 15 or more employees. So we talk about it, one, because it's a benchmark, it's basically information for you. Two, some of you out there may have 15 or more employees, or you'll grow and you'll have 15 or more employees. And as you grow, you just need to be mindful of this stuff. So, so the rule is, it doesn't automatically violate Title VII, at least on the federal level. But if you use criminal information, it could indicate that you're selectively screening employees for other reasons. And, also arrest records are unreliable indicators of guilt, according to the EEOC. So you ask about arrests that are related to a position in question, but California law prohibits that, so be aware. Background checks, I don't know if you're doing background checks. Background checks are one of those issues where, again, you have to be really careful about what information you ask for. You really want to prevent negligent hiring lawsuits. You want to avoid, but you want to avoid hiring people that have, that don't tell you the truth in their application. There's issues about workplace safety, loss prevention, legal obligations for certain positions. If any of you are in a home health care industry, for example, where you put workers into people's homes or they have contact with children, then you have to be more concerned about those kinds of issues. But there's limits on what you can get. So we have the Fair Credit Reporting Act, which is a federal law, covers all types of consumer reports, which includes credit reports. And then you have California law, which has its own investigative scenario about investigative consumer reports. If you have a company that you deal with, for example, if you have a payroll company, someone who helps you do hiring, they probably, some of the big companies, ADP, Paycom, they have their own. If you want to buy more services, they have those types of services available. But the key thing for y'all to know is if you're going to do this, you can't do it in secrecy. Because see, if you're an employer or a potential employer, you want to do stuff in secrecy. You want to typically want to get the information on an employee so that you find out what the deal is, but if there's anything in their record that would cause you some concern. And you really want to do it in secrecy because you in an ideal world, because you don't necessarily want them to know you're checking up on them. Or maybe not, maybe that's not how you do it. But the point is, you can't do it in California. There's notice and disclosure requirements, and employees should specifically authorize or sign a release so that you can obtain background checks on them. Internal reference checks, you basically say to people, give me your last 3 places of employer, and on your application it says, I'm going to check your references. They're generally okay with that. If you can make those calls, get that information. You can look at public records if you're really inclined to do that, to see if you can find arrest records. They're notoriously difficult to find because there's no central database for them. And be really careful about things like social media searches. People put stuff on social media that maybe they come to regret. I mean, it's not my job to tell people how to use social media and what to post or not post. But you've got to be really careful. If you're going to look at somebody's Facebook page, you're going to look at somebody's Facebook wall, you have to be really careful about that. And you really can't do things like say, give me your password, I want to access your Facebook or your LinkedIn or your Snapchat or your whatever it is you're using. You've got to be really, really careful on that. And you can get, you can wind up being on the wrong side of a claim from a disgruntled potential employee. Offer letters, these are some of the documents we talk about what you can decide to use. There's no requirement under California law or any other law that you actually give somebody an offer letter. But you have to decide for you is, should you do it? And if you do, you really have to think about, what do I want to put in the offer letter? Basically, in terms of employment, position, salary, classification, exempt or non-exempt, what are their hours, what are their start date? Contingencies, you know, if there are any, drug test, a background check, whatever it's going to be, you put in that an offer letter as well. Anything with respect to, you know, we need you for the next 6 months and that's all, or we expect, you know, we're going to have a long, productive relationship with you where you're promising employees that'll be this way forever and ever. You don't want to use that. As far as promises of future compensation, you really don't want to do that. And other promises you may not be able to keep, whatever those are. So just be careful. Employment agreements, again, do you need them? Do you want them? Those are personal decisions that companies will make. And you can decide to have it for some employees, not all employees. If they're useful, if you really want to lay out what the ground rules are, that this is their deal, and we want you to acknowledge that this is our deal. So for some companies, they actually like written employment agreements. And sometimes you need it if you want to attract a certain type of candidate, someone who's highly skilled, someone who's going to be, you know, a high level in your company. But the cons are, it does limit your flexibility. It basically is the deal, which means that, oops, just change the slide, which means if you're going to write it down, then you got to live with it too, because it's going to be mutual. So be careful what you write. And if you really want maximum flexibility with employees, you just need to decide if you want an agreement or not. Hiring forms and notices, even if you're a small company, there's lots of stuff you need to give people. And for those of you who already are hiring employees and have employees, you may already know this. So in this case, it's just a little bit of a review for you. I-9, legally able to work in this country, is a baseline. Tax forms, a W-4, California DE-4. The labor code form, notice to employees when you initially hire them, which has certain information. All of these forms are available online. You just need to be careful using the most current version of it. And then depending on, you know, the size of your company, there's state pamphlets and notices employees have to get, paid family leave. If you have one or more employees, you need to have a workers' compensation policy. If you don't, that's a problem for you. Even as a small company, if you have one employee, that's enough. You need to have a comp policy. You need to give people notice when they're hired of that the fact is you have a workers' compensation policy. If you have a work comp carrier, they'll usually will give you a pamphlet, or you can download the pamphlet. One or more employees, people are entitled to state disability insurance, which is withholding from their wage. Employees pay for it, but you've got to set up an account so that you're withholding it from their wages. Sex harassment information policy, there's a pamphlet for that. And every company should have a sex harassment policy. As I told you in the beginning, one or more employees, sexual harassment is a law that applies to you, just like some of the other laws we've been talking about. Domestic violence, sexual assault, those are also pamphlets depending on the size of your company. Stalking is another, is another pamphlet. Health insurance notices, if you provide health insurance for your employees, you need to give them you need to give them the appropriate paperwork. All right, so some of the best practices that we recommend that y'all think about doing. If you have folks other than you who are involved in the hiring process, you really want to make sure they're trained, that they've got some baseline understanding, as you do, with respect to things they can and can't ask, things they can and can't take into consideration, promises that they can and can't make. So again, that involves some knowledge and understanding with respect to the equal employment opportunity laws and background check laws. So you need to be careful who's doing this for you, and you need to, of course, comply with all this stuff. One of the ways you do that is you have a process. You basically have, a screening process, for whatever it is you're gathering, assessing job relatedness with respect to, arrests, convictions, bankruptcies. You need to be careful about all those issues. disparate impact about hiring decisions. I mean, that just means you're not making decisions for impermissible reasons, race, sex, color, creed. Second level review for hiring decisions, if you're delegating this to another employee or someone else in your organization. And, you know, basically you want to have whatever paperwork you have at the end of it, you want them to be, you want that information to be provided to you. Termination, this is the other issue.
Ed, could I take a pause real quick? We have a bunch of questions coming in on hiring, and I thought this might be a good time to ask some of those questions. Unless you prefer, we could just ask all of them at the end.
I think we're okay on time, so let's go for it.
So yeah, we've had a bunch of questions, so I appreciate everyone's attention, and I'm going to go through them for you. But the first one I'm going to ask is on the application form slide that you had. So if you, as a company, have an application form, there was a section about disclaimers, and one of the disclaimers was no contract created. And we were hoping you could give a little information about the disclaimers and what that specifically means.
Oh, great question. Yeah, the disclaimers include a lot of different things, which is, you know, we're an equal opportunity employer, specifically with respect to, you know, no specific contract term. In employment applications, generally, there should be an at-will provision, which essentially says that, you know, as I mentioned before, you know, it's an at-will. This can be terminated anytime with or without cause, with or without reason, either by the applicant or by the company. And there's no express promises implied to the contrary. So that's one of the most important disclaimers. If you're going to do things like background checks, that's not exactly a disclaimer, but that'd be something that would be printed on the application form with a place for the employee to acknowledge that they're doing a background check. There's probably other things, but just off the top, those are the things that always, when I'm reviewing an employment application, jump out at me. And the other thing is, of course, if there's anything in their form that says, you know, what's your age? That's an impermissible. It's not a disclaimer, but it's impermissible. And, you know, even for education checks, you know, most of the companies have eliminated the years that you went to college or the years that you went to high school, because that shows how old you are. If you graduated from college in 1985, you can do the math and figure out how old someone is generally. So that's generally it. One of the things that I look at, some of them, not all of them, but that's some additional information.
That's very helpful. Thank you. And thank you, Annalena, for submitting that question. I think also the no contract created, like specifically means like there's a difference between an application form, right? And then like you know, something else later. Like you want to be very clear on the application form that this isn't an offer of employment. You're just applying, and make that very clear. I think
exactly. No, really good point. Yeah, and that'll be on applications that, you know, just because you submit an application, there's no guarantee that we're going to hire you. And, you know, it's just part of our process, but you're absolutely right. Yeah. So this is helpful because you can screen any application forms you're using to see if there's issues or concerns that you can see. And I candidly ask yourself the question of, if I was applying for a job, would I want to list that information?
That's a really good point. Our next question comes from Stacy Cumberbatch, and she says, we work with local governments and are asked to give preference to local hires and diversity. Is that type of preference okay? We say we are an equal opportunity employer and aim to reflect the communities we work with a goal of, you know, 30% local and diverse hires, for example.
Yeah, great question. That's one of those questions where it really does depend on the circumstances. If you're performing services under a government contract, then you see with a lot of government contracts on all levels, state, local, federal, you'll see requirements with respect to, certainly with respect to EEO. A lot of public agencies also require statistics from you with respect to the composition of your workforce. So there's nothing illegal per se about it. And I think the question becomes, do I have to, you know, because I have to give preferential treatment for certain people with protected characteristics. The other side of the question becomes, just in general, I mean, the real answer is we'd have to really look at this and see what the contract says. But just taking that question a little more generally, the issue does become, is it reasonable under the circumstances for the area? Do you have to worry about rights of non-protected people? So they have protected categories, or they're encouraging you to hire. What about the folks that aren't protected? Do they have a claim against the company because they feel like they're being reverse discriminated against? So yeah, that would require a whole lot more review, but that's the general framework for it. And again, as I said, I can't answer specific questions, give you specific legal advice. I can give you generalities, but all of this stuff requires the actual, boots on the ground, looking at this stuff and really assessing it. And that's where you come in, Matt.
Yeah, I love that question because and thank you for teeing that up because I was going to make a plug. Since this is an information only webinar, one of the other services that ICLS has is a legal clinic where we match people up for one-on-one meetings where you can ask specific questions. So if you're interested in doing that, I think employment law in general and that specific question, there's a lot of gray, right? It'll depend on the facts of your workplace and the types of questions and the context there. So please feel free to apply for our free legal clinic. There are eligibility requirements, including income and asset guidelines, but that is one service that we provide. If you are not eligible, that means that our funders think that you can afford counsel. And in that case, you may want to see an attorney on that specific question. We have a couple other questions. I think they're probably relatively quick, but one question from Stacy as well, and I Sean thumbs upped it, is during the hiring process, are personality tests like Myers-Briggs, are those okay?
Oh, I love that question. I'm no expert on that, but and they seem to be one of the flavors of the month that some companies they embrace and they don't embrace, and there's tons and tons and tons of tests out there to try to figure out, is this person going to be a good fit, which I hate that expression. You don't use the term good fit with respect to hiring decisions. So I would say generally it's going to depend on the job that they're applying for or what are the requirements. Myers-Briggs is a test they use. From my understanding as a layperson, it uses a very specific reasons, very specific purposes. It's a test that has to be administered by someone who's a psychologist that knows what the heck they're doing. And then of course it delves in the details as far as interpreting it. And that's just one of them. There's tons of them out there. So I would say on that one, again, before you decide to go that route, you probably really need to call Matt and see if you can get a consult. And candidly, it's going to depend on the job. What job are they applying for? And why do you need it? Again, remember what I said. It's just because you may want to know something, you got to ask yourself, why do I want to know this? Do I need to know this? And then what am I going to do with the information once I know it? Because that's the other part of it. So you need to be careful what you ask for, not only because you may get it, but because you got to figure out what to do with it afterwards. And then employees have rights to privacy. You don't give up a right to privacy just because you want to apply for a job at a company or because you're working at a company. You still, you don't check in all your rights at the door. So you just have to be careful and seek appropriate legal advice. But it's a great question. I love that question.
Yeah, and I'll add to that too. I mean, some of the personality tests, because there's so many out there, they could have questions that are, in effect, trying to seek information about discriminatory or protected traits. So they may categorize you into, older or younger or this or that. And those types of personality tests are particularly problematic.
There's reams of bias, about implicit bias, about actual bias. There's reams and reams of information on all of that stuff. And way beyond my pay grade.
Yeah. And then the last question about in the hiring section, it's more of a concept, and a few people mentioned this, and whether there's a difference if one is hiring someone as a freelancer, independent contractor versus employer. And I know, Ed, we were talking about this before, because it is a big issue.
Great question. Come to our webinar on Friday. At the end of this, there's a slide that says, y'all can sign up. Cozen O'Connor does webinars. I'm doing a presentation with two of my colleagues on Friday at noon Pacific time. If you really want to find out a little bit more about independent contractors, pros and cons, do's and don'ts, the gig economy, sign up and come, because you'll get a lot more information. Candidly, the issue of independent contractors is separate and apart from what we're talking about. If you're gonna hire independent contractors, yeah, come to the webinar, because it's a complicated area. The laws have changed dramatically. I get small companies. You may be somebody's independent contractor. You may use independent contractors because you think on a short-term basis it's going to save you money. But at the end of the day, misclassifying somebody as an independent contractor is going to cost you more money. So you just need to be really careful. I encourage you to sign up for our webinar. Matt, I really do need to move on. I want to cover terminations.
Sounds great.
Cool, thank you. All right, so again, when you're getting ready to fire somebody, with or without cause, with or without a reason, you gotta ask yourself some of the following questions. You gotta really review it. Hiring somebody is a real serious matter. Terminating people can also be real serious. And those are two of the biggest parts of our job. And if we have companies, this is probably, a lot of people love hiring and hate firing. Some people actually love firing. Those are rare. Most of us hate this conversation. We really hate to get rid of people. We hate the part of the conversation that we have to tell them. But ask yourself some of the the basic things. Do I have a valid business purpose? Am I letting this person go for a legitimate business reason? What do our policies say, to the extent we have policies? Am I treating people the same? Am I across the board, if I have more than one employee, or however many employees I have? If I need to do an investigation, have I done them thorough? You need to look at personnel records. If you keep personnel records about write-ups, if somebody's a problem employee, you've got to be really clear in giving them a performance improvements plan. Doesn't have to be formal, but it just says, hey, you're not doing well. We need you to do X, Y, and Z within a certain date, and then we're going to review your performance again, and let people know if they continue to make errors, or that you continue to not have them do the job that you need them to do, then that could result in their termination. And in lawyer speak, you guys talk about personnel records and human resources records and payroll records. Most of the time, well, I don't advise companies. Most of the time I defend companies and lawsuits that have been filed against them. And this is evidence for us. To the extent you keep good documents on what you've done and why you're doing it, it's something that's critically important. You can't make it up after the fact, but documents that are provided concurrently with whatever action you're taking for employees, especially things like performance reviews, and such, should be communicated to the employee. They should acknowledge it. They should sign off on it. So what do you tell people? This is another part of the job that most people don't really like. But what you try to do, there's no magic to it. Sometimes, I differentiate. For example, if somebody shows up drunk at work, or God forbid, somebody shows up with a gun, or God forbid, there's some other thing that is just so egregious. At that point, I think, one, you got to keep everybody safe. You got to do what you can. But, candidly, in a situation like that, terminating an employee is kind of the least of the concerns at that point. So there's certain things I just call fireable offenses, where you're not necessarily going to, jump through a lot of hoops and try to have a nice meeting. You're going to have to secure your workplace. Those are rare. They happen, but they're still relatively rare in the day-to-day life, but we all need to be concerned about that. So what you want to do is make sure that you treat this person with respect, with dignity. You want to do it, generally speaking, you want to do it late in the day. You want to do it at a private location. It doesn't help to be theatrical and walk into a room where there's other people around and say, Joe, you're fired. We view that as being a non-productive way to do it. You have to figure out whether you're going to ask the employee to leave immediately and escort the employee out, let them gather their things. We do not recommend, that you, generally speaking, that you terminate an employee and then kind of leave them unsupervised, depending on what your situation is. I mean, we have examples of, databases being completely wiped out, companies being sabotaged. It may only take a few keystrokes, so you just need to be concerned about that. Prepare something in writing, keep it simple. Be consistent about the reason. Don't apologize, don't make small talk. Avoid, bargaining, antagonizing, negotiating. Again, don't physically touch, try to restrain somebody. And then again, focus on the walkout, because that may be, a very important thing at the end of this all. You want to try to get that person out of your work environment as quickly, easily, safely as possible. RIFs and group layoffs. I'm not going to talk about this because candidly, this really applies to larger companies. So those of you who have worked for larger companies may be aware of things like, reductions in force, group layoffs. If you get to the point where you're really big and you really need to think about, riffing people, or you're having a group layoff, we can talk about it. But again, the takeaway is I'm always going to be consistent. You got to treat it, you got to be consistent. You can't discriminate because of protected characteristics. And it has to be for a legitimate business reason. So are there alternatives to layoff? Yeah, I mean, this candidly could apply to termination decisions too, even if you're a small company, reducing compensation, it's telling somebody they need to take some time off, pay freezes, or early retirement incentives, not so much for you all. I don't think performance-based buyouts, probably not a real concern for you all at this point. But EDD does have a work sharing unemployment insurance program, which some companies like to take advantage of. That's all I'm going to say about that. So best practices, there's no art. I mean, there's no science to this. It's more art than science. Sometimes you get a good feeling about a particular employee. Sometimes you get a bad feeling about a particular employee. That's the fun part about doing what you folks do when you're entrepreneurial and you're having your own business, because that's your opportunity to get employees that you think are really going to help you shine as a company. But again, you always need to, oh, this is a RIF plan. This really doesn't apply, but I'm going to talk about it because maybe the next slide covers it. Because you really, if you're going to, I'm not going to talk about that. I'm sorry. It's just really beyond the scope. WARN Act is a federal law, California WARN Act. That's also beyond the scope of really what we need to talk about. You got to have 100 or more employees to be subject to it. California, you got to have 75 or more employees. So if you get to the point where you're big, if you're a big company, you need to think about that. Now we'll talk about final paycheck requirements because you folks need to be mindful. Remember, one or more employee, and you need to make sure that if you're giving somebody if you're firing somebody, you need to make sure that you're ready to pay them any final wages that they have due. And that means that you need to follow California law, which has some really specific requirement about payment rules. If someone resigns without notice to you, then you've got to give them their final paycheck within 72 hours. Basically from the time of quitting. And that includes weekends. So if someone quits on Thursday at 5 p.m., final wages need to be paid by Sunday at 5 p.m. And if you discharge somebody, you know you're going to terminate them, but they don't know you're going to terminate them. Then at the time you terminate them, you have to have their final paycheck that's ready to be paid to them instantly. I mean, you need to hand them their final paycheck. If they do automatic deposit, a lot of people ask me at this point, well, what if they do automatic pay? What if they do automatic deposit of their paychecks? Then you ask them. You need to let them know. I mean, I recommend have a paper check ready, because if you don't pay them on time, then penalties start to apply. You can be liable for up to 30 days of wages by not paying people their final wages on time. So I recommend you have a paper paycheck available. Some companies will say, well, we have a payroll service. How do we do that? You know, payroll cuts the check. We want them to wait until payday, till regular payday to get their checks. Employees might agree to that, but if they don't, they could go to the labor board and you can be liable for however many days it takes you to get them their final wages up to 30 days. And that could be a lot of money, even if it's an employee that makes minimum wage, that can still stack up to a lot of money. So again, remember, if they quit without notice, 72 hours, you got to have their paycheck. If you're going to fire them, you need to have their final paycheck ready. If if they have overtime has to be paid. If they've got unpaid vacation time or PTO time, if your company gives that, any time that's accrued and on the books that hasn't been used has to be paid. Then you've got to, when you pay them, you got to pay them at the place of discharge, and that just means your location. So what do you include? We talked about it a little bit, but again, it's the wages that they're owed, unpaid at the time of termination, premium pay, bonuses, commissions, vested vacation, PTO. You of course can deduct from their wages the authorized deductions. And now, one of the issues that comes up if you loan money to your employees, a lot of companies at the time they have a monthly payment arrangement with that employee, and then the employee quits. A lot of companies say, well, they owe me more than the wages that are owed, so I'm not going to pay them their final wages, and I'm going to apply that against the amount that they owe me. That's illegal under California law. If their agreement is to pay a monthly amount or a weekly amount to you, you can take that out of their final paycheck. And if it's a monthly amount, meaning they take it out and you take it out of every paycheck, or what, you need to make sure that's the appropriate amount. You may need to cut it in half if you pay people twice a month, or it's more complicated if you pay people biweekly, which is 26 pay periods a month. But you can only deduct the amount the employee specifically authorized. You can't do this thing like there's a balloon payment. And I already mentioned this, and I'll just mention it again. Under Labor Code 203, waiting time penalties, if you have a lot of employees and there's a lot of people that are subject to this, these penalties stack up a lot. Again, you could be liable for up to 30 days of unpaid wages. That gets to be a lot of money, and that's in addition to anything you owe them on the wages. And again, if there's a legitimate issue, and this is where sometimes you need to reach out to Matt, you need to reach out to a lawyer, you need to, sometimes the Labor Commission will help you. If there's an employee just doesn't want to accept payment or refuses to receive payment, then they're not entitled to waiting time penalties for evading it. If there's a legitimate dispute as to whether somebody's owed money or not, you may not have to pay the penalties, but those can be complicated circumstances. So do you have to pay somebody severance? Do I have to pay you walkaway money if I let go? If I let you go? There's no legal requirement that you do that. You don't have to pay somebody severance. You don't have to pay them separation pay. And if you do, the short takeaway for us is if you're going to do that, you really do need to talk to a lawyer. You need to think about it, because one of the things you want to do or try to do, if you're going to offer somebody a separation payment, you really want to be able to get a release of any claims that they may have against you. And that's going to depend on the circumstances. So there's lots of legal risks there. There's some goodwill, giving somebody some separation pay when they leave. But you've got to really think about that. If you have insurance for your employees, if there's benefits, outplacement assistance, these are probably going to be things, references you got to be careful about. We tell people neutral letters, neutral references, which is name, rank, and serial number. You verify the dates of employment. Assuming you have a release from them, you verify the dates of employment, you verify what their jobs did. And if they provide you a written release, you may give them information with respect to the last wages that they earned. You gotta be really careful about that because you really don't even want to give that information in the absence of a release. And so if you're gonna do a release, there's concerns with respect to what you can ask. what you can ask for in a release and what you can't ask for in a release. So claims that you can't ask them to release is workers' compensation claims. Under California law, you can't require an employee, as a condition of paying them separation pay, to waive any workers' compensation claims that they may have. That's illegal as a matter of law. You can't ask them, you can't say, I'm going to pay you this money, but you can't file a claim against me at the labor board. You can't file a claim against me at the Department of Fair Employment and Housing. You can't file a claim against me with any other agency. Whistleblowers, another issue. You cannot, those are all illegal. You can't ask for that. You cannot ask for that in a release. You also can't, there's big issues with respect to no rehire agreements. That law kicked in 2020. You can't, generally, you really can't have people sign a settlement agreement that forbids them from getting, coming back to the company and reapplying. There's issues and concerns on doing that. There's ways to do it. You just have to be careful. If you're going to want a provision like that, you really need to talk to a lawyer because there's a lot of ins and outs on that. And again, if you have a legitimate reason, non-discriminatory reason that you're not going to hire them back because of something they've done, or how they've behaved with the company, then that could be an exception. But these are complicated areas. So if you're going to have a severance agreement, you could be very careful. Confidentiality provisions in an agreement, same thing. If it's related to sexual harassment and sexual abuse, probably running out of time, but you've been careful on that. ADA, if you have sufficient number of employees for ADA claim, then you have specific timing issues with respect to getting a release out of somebody who's over 40. References, be careful. You have to have somebody in charge of responding to reference checks from your employee, somewhere human resources. If you have a piece from human resources, whoever's doing that function needs to be consistent, confirm the dates of employment, positions held, rate of pay at the time of separation, if you have a release agreement. And don't answer any questions about their work performance. The legal risks are you can get sued for defamation, interference with contract. You gotta be really careful about that. Exit interviews, do you do it or not? Do you do exit interviews? Some companies do them, some don't. It has to do with this whole termination meeting. But a couple things you do want to do, even if you're a small company, you want to get back your company property. So if they've got a company cell phone, they've got a company computer, they've got a company car, you want to make sure you get your company back, company property back. If, like a lot of companies, it's like people are bringing their own devices to work, they're going to have a lot of stuff that belongs to the company that's on their devices. So you need to do what you need to do, work with an IT expert or however you're doing it to make sure that you get your company data off of their devices. It's easy to say, it's sometimes hard to do because now everybody, it's all BYOB or BYOD. And so you've got to be really careful about trying to get back your information. And then getting rid of any confidential information. And also in an interview, you'll find out if somebody really is just so steamed they intend to file any claims against you. Termination paperwork, final paycheck, expense check, severance agreement, if offered, give them an unemployment insurance pamphlet, notice to employee of change of relationship online, EDD for your benefit, unemployment form, COBRA if you have insurance, is a whole other issue. Health insurance premium is a HIP notice. HIPAA, a notice of credible coverage if you have insurance. Retirement plan, maybe way beyond the scope of what y'all do. So basically best practices, at-will policies and practices, we've talked about them. Try to train people as best you can, be consistent, take your performance reviews seriously, be accurate, investigate for terminating, discipline without delay, document. Where it's evidence to lawyers, document for you, so you know what happens. A year or two goes by and you don't remember what you did with that person. If there's alternatives to just terminating them, you think about it. Don't be inconsistent, be consistent with whatever that message is. Yeah, be aware of legal developments. I mean, that we put in, but there's stuff is always happening. Legal landscape continues to evolve much more quickly. And when you need to reach out to Matt, get some legal advice. Here's some upcoming, I talked about it, June 24, 2 days from now, we're doing, let's talk about independent contractor laws, best practices of California employers. We do an HR series for, which is basically a boot camp. So we try to keep it baseline, sort of what we did today. We try to keep it so that it's a good opportunity for small companies, big companies. If you're really experienced, it's a great review. If you're not so experienced, it's a good introduction to a lot of different topics. And we have other topics that's coming up. We've covered wage and hour, we're doing independent contractors, we're going to be doing disability, harassment, and some other things that are being announced. You can go online to our website, Cozen O'Connor, you'll see there's a lot of free content. You can sign up for webinars, you can sign up for newsletters. All that stuff's free. Nobody's going to call you, nobody's going to bug you. You know, and it's value. The good news is there's a lot of information on there. The bad news is there's a lot of information on there, and it's not one size fits all. We're a multi-state law firm, multinational law firm, so not all the stuff's going to apply, but we've got some good California stuff up there. And on that, I'm done.
Well, thank you so much, Ed. I think one thing that's great is Shauna actually signed up for and circulated the link to sign up for this week's webinar on the independent contract. So that's fantastic. Yeah, it's in the chat. I'm also going to circulate the link in the chat right now. If you're interested in learning more about ICLS's other services, please do that. But I wanted to take a moment to really thank you, Ed, for joining us. It is a long presentation, and I think you made it really easy to understand. But I think you also made a really important point. Employment law probably is one of the most important things to think about as a small business owner. Not only is it complicated, but there are so many different types of laws out, or different laws, and it's not just the labor code, it's all of these other complex laws in California and federal laws as well apply to you. So while this information is super helpful, and we will circulate the slides, I think Ed mentioned a few times, there's a lot of gray in some of these issues. So please feel free to reach out to ICLS if you think that there's something we could do. And also, if you do have an employment question, since this was just an informational session, you should reach out to an attorney. And hopefully ICLS can help if you're eligible. But if not, you may want to seek an attorney on specific issues.
Right. Yeah. And don't forget, I'm going to say one other thing, and then we'll go. Don't forget about trade associations, because they can be really helpful. Your local chambers of commerce, your local business groups, restaurants, for example. I think there were some restaurants here that may be attending. California Restaurant Association. Some of the stuff they do is for free. Sometimes you got to sign up to do it. CRA is a wealth of information. Their purpose exists to try to help restaurateurs, you know, stay in business for a lot of different reasons, operationally, as well as dealing with issues with respect to employment. They've been out in the forefront. Chambers of commerce also can be terrific places. Certain trade groups, business associations, voluntary organizations. A lot of those folks have resources that are available. The Better Business Bureau. Matt, you probably know way more about this stuff than I do. BetSEDEC is another organization. So there's lots of stuff out there. Again, the good news is there's resources available. The bad news is you really have to sort of chase them down. But yeah, good luck to you all. I mean, you know, continue to do well and thrive in your businesses, and I wish you the best.
All right. Well, thank you so much, everyone. You know how to reach me and Ed if you have any other questions. And we will be circulating the materials later today.
Perfect. Thank you.
Bye, all.